you. Good afternoon. It's now 2 o'clock on Thursday afternoon and time to begin our board meeting. We have an agenda in front of us. Do I have any changes or amendments to the agenda? If not, may I have a motion to approve?
Microphone on.
The agenda is presented. Please signify by saying aye.
Aye.
Any opposed? Right. Executive Director Corinne Duncan.
Thank you. I do have some office updates while I have you here. I wanted to assure you that the absentee ballots are out, so that means we are officially voting. Sample ballots are also available, so people can go online and get their sample ballots. We also at your stations have some resources for the board. So these are our two main outreach things that we put out every election. One is the 3 ways flyer. It gives 3 ways that people can get ready now, register, check your information, get your sample ballot, those kind of things. And then the 3 different ways to vote. And then the small palm card is the early voting palm card. So that has all of the early voting locations on it. So we want to make sure that you had that. And those things we have lots of them. So if you want more of it to bring to your community, you are welcome to do that. Training has also officially started. So right now we're doing early voting training over at 200 College, and then we'll move to 40 Cox for election day training. She is in training right now, but we have hired our outreach coordinator and she started on Wednesday. Her name is Rachel Wunderlich. She previously worked for the county in a contract capacity with the Helene Resource Center. So she's really connected to the community. I am excited that she's joining the team, and as soon as she's available, we'll introduce her to you at one of our meetings. And those are all my updates.
Any questions? All right. Well, we have our county attorney, Mr. Euler, here today, and basically here to assist us and walk us through.
Actually, I'm sorry, Madam Chair. I guess we're going to tackle it in office update. I did have some questions about what's going on. All the board members received an email about a public records request. And I'm wondering, really what's going on? And is this statewide?
So I don't know if it's statewide. I do know that other boards have gotten the requests though. Not unique to us, if that's what you were.
Okay. Yeah.
Yeah.
Okay. So they're not singling out Buncombe County.
No.
Okay. I have never heard of the requester before, American Oversight, and I'm just not familiar with them. I tried to find information and really couldn't. There wasn't anything. I was just wondering if anybody knew anything.
We get so many records requests. It's not alarming to me. It's
Okay.
just is different because it was to the board this time. So
Yeah.
So that feels different to you, but you're correct. It's not unique to our board.
Okay. Is there a deadline for responding to this?
So the deadline for public records requests in general is as soon as possible.
Okay.
So we had a deadline for you all to get information to us so that we could respond soon.
I couldn't find anything, but I don't know. Okay, thank you. I just that request threw me off.
It's not usual for the
I
board
hadn't
to get
seen one like that
requests.
before.
I do have to say, I was kind of like, all right, the board gets to see what we have to do now. And it is a very good reminder, right? That everything that we do in business and the name of the board and elections is requestable. And so it's a very good reminder of that. Use your laptops, use your, county emails, and it helps Kurt be able to find that information for you and to respond to requests.
I had learned the names of social media platforms that I had never heard of before just from that laundry list in the request.
This might also be a good time just to make the reminder that when you are doing business as a board member, make sure that you have a distinct separation between your personal email accounts and your personal cell phones, as opposed to your Buncombe County, your county email addresses, because if you use your personal emails and stuff to conduct county business or to conduct Board of Election business, that is still considered a public record. So just make sure it's just easier for you. And I recommend to all of our elected and appointed officials to make sure that you try to keep as much of a separation as you can.
Thank you.
I thought that in that email it said that they wanted, what they were requesting information on a personal phone and email as well.
That would be that if you were using your personal phone or email to, basically do conduct business as a member of the Board of Elections, but you don't have to turn over your personal emails that have nothing to do with the Board of Elections or where you're not conducting any public business.
And thank you, because you reminded me that appointed board members are subject to this. And I'm just looking for the annual feedback on the ethics disclosure that we all got emails, I think, recently on doing ethics disclosure. I did.
Oh, that's a county thing.
Okay, but no. But I'm an appointed person. I'm not really an employee, even though that cool document tells me that Corinne Duncan is my manager.
You're talking about the annual disclosure.
Yeah.
Yeah, the board does not have to do the annual.
We don't have to
disclosure.
do that. Okay, just
Just on all the emails.
no, I just want to make a point. And if you wouldn't mind sending this up the chain, please don't send me an email that is not relevant to me. No, seriously, that's not hard to do. And if they need some help, I'm happy to come in and help them put together their mail out lists. I'll have you know,
Okay, and so-
I'll have you know, I complied. I submitted my disclosure today. Fool that I
All
am.
right, so now as we move on to the presentation on candidate challenges, Corinne, I think you're going to walk through the presentation, and then Kurt's going to help us with questions, or if there's any concerns, or if it makes you folks feel any better. Kurt has helped me learn my role in this and how to handle a hearing to the best of my ability. And today is so that we're all trained and aware on how to conduct this particular type of business that's required of us in our roles. So
Yeah, we had a challenge 4 years ago, but it ended up being withdrawn because the candidate dropped out. Remember that for sheriff?
I
And,
do actually.
We never had to make findings or issue a conclusion or anything
No,
because he
you're-
dropped out. So this is the first one that, I mean,
It's
I've
a
been doing.
candidate. We've had a couple voter challenges.
Oh, yeah.
but we've never had like an actual candidate.
Yeah, I've been
challenge
doing
like
this for
these.
many years and I've never seen one go
this
the distance. So I'm real curious.
All right, can everyone hear me? My
Loud and clear.
lavalier is working good, and we've got a presentation up on the screen, and you all have the PowerPoint in front of you as well. So thank you all for making the time to be here. This was a impromptu meeting, and what I'm going to do is present on the procedures for the candidate challenge hearings, and that'll help us prepare for the 2 hearings that we're having on Tuesday. Kurt Euler, County Attorney, is also here to pipe in when needed and answer questions. And then he or a member of his team, specifically Amy Broughton, which you have met, will be here at the hearing. on Tuesday. So we'll have them there as well. And before I really get into things, I do want to thank Nate. His experience in JAG with the Army has been really, really useful in preparing us for this. So thank you, Nate. Candidate challenges are definitely one of our most formal duties. Though Glenda is going to preside over the hearing, we want to make sure that we provide this time to give an overview so that everyone's on the same page and that we're feeling comfortable with what we're doing. Because it's true, it's been a very long time since this office has done a candidate challenge. So I'll give the overview, we'll take questions, and get comfortable with the process. Previously, you were given the proceedings, which we printed those out again, so you have them with you. The proceedings are really legalese, so but they are there for you to read through. We also gave you the candidate challenge guide that the state board put out. We printed that out for you. And then you also have this presentation, and I definitely encourage you to follow along and take notes on it. And you might want to take it with you on Tuesday.
I have a question, Green, about the proceedings.
I've got the conduct, I've got the actual law.
That we printed out.
Oh, it's proceedings
For each candidate.
Yes, yep, the proceedings were given in the notice to the candidate, yep. So you have kind of that packet that has the challenge form and the proceedings with it. Good question. And then at the hearing, in addition to the video of this meeting, we'll have a court reporter. So they'll also be recording the hearing. And just a reminder that it's likely that we're going to have media present. And that's okay, they can be there. Yeah. 2 notes. So during the hearing on Tuesday, things might get wordy. We've kind of scripted things out, and that is on purpose. So we want to, I'm asking you to bear with the specificity, because it's important that we're making sure that we're carrying everyone along with us, so everyone in the room knows what we're doing. The challenger, the candidate knows what we're doing. The board knows what we're doing. We're all on the same page and we don't get lost. And we don't want to miss any steps. We don't want to do this again. We want to make sure that we get it right. So I just wanted to warn about it'll feel very formal and stilted, but that's on purpose. And then second, it's very important that we remain civil and respectful no matter what other people might be doing. And it's, Glenda's charge to make sure that we keep order. So she will do that. But we are professionals. We set the tone. So we need to make sure that we're doing that. Again, you have the presentation in front of you. I think it'll be good to take notes on that. You'll probably want to bring it with you on Tuesday. And I'm providing a big picture overview first. Kurt's here. I think you'll probably want to hold your questions until the end. If you absolutely need something, though, that's why we're doing this. Ask questions. We need to make sure that there's clarity before we leave today. But I think doing the overview first will really help with that. But please pipe in if you need to. So let's get started. Let's move to the first slide, please, Samantha. So this is the hearing overview. So there are, again, we'll hold the 2 hearings, January 20th. We'll start at 2:30. So we'll do the first hearing, which is the sheriff's challenge first. Then if we need a brief recess, we'll do a brief recess. And then we'll come back and we'll do the second hearing after that. And that starts at 2:30. This is a quasi-judicial hearing. And in that proceedings, it talks about the panel. You are the panel. The board's the panel. And the chair presides. Again, legal will be here to assist if needed. Our clerk will provide admin. So there are times when statements need to be timed. So she will do that and gather documents. Like when evidence is presented, she'll get that and pass it out to you and all of that. So you're actually not going to hear a lot from me during the hearings. So the basic parts of this type of hearing are we will start with a chair introduction. So she's going to do a shorter version of what I'm doing right here, letting the audience and the candidate and the challenger know how the hearing is laid out. So she'll do that first. We'll also talk about how the timing works and those sort of things. So she'll do that first. Then we'll move into the actual hearing. So we will allow for opening statements, and we're going to go through each one of these in the presentation in detail, but I want to give you an overview first. Then we'll do the case in chief. That section is the meat. That's the evidence. That's where the candidate is defending themselves, and they have the burden of proof. So unlike other hearings, the burden of proof is on the candidate. After both sides have been given their chance, and again, that's the big piece of the hearing, then relevant audience testimony and evidence may is the right legal word, give evidence. That's up to the board. So the board can choose whether to take that evidence in or not.
Wouldn't any of the evidence have to be sworn in?
Yes.
Yes.
Yeah. We'll go over that.
They
Yeah.
would.
Absolutely. Mhm.
Thank you.
Yeah. They would have to take an oath. And then we'll do closing statements, and then we do the deliberation, and that's you all talking about what you saw, and that's an open session. Then you'll make a decision, and you'll do that by motion first. And then we have to issue a written statement. And we'll do the written statement. We have a draft of written statements so that we can edit them quickly. But issuing them right then, I wanted to do that. I wanted to issue it right then. But we need to make sure we're not making any grammatical errors or whatnot. So we'll take those. We'll be able to turn it around quick. So I expect that we'll be able to turn it around the next day. But technically, we have 20 days to do that. We don't want to take 20 days. We want to make this quick. All right, next slide. So now we'll go into each of those pieces independently. So the chair introduction. In that introduction, Glenda will announce all the parties, and she'll do this for each hearing. So we'll duplicate this each time. So, if someone wasn't present for the first hearing, they're going to hear it in the second hearing. So she'll announce all the parties that are present. She'll cover the allegation that was filed. So she'll kind of make that same statement that is from the actual candidate challenge. She'll remind that the burden of proof is on the candidate. And then she will explain the legal standard. The preponderance of evidence is the legal standard. And later in the presentation, we'll go over how do we determine the preponderance of evidence. And then she'll also cover some other administrative details. Of, how does the timer work? How do we give oath? So that's the introduction. The next piece is the opening statements. So these are optional. Opening statements and closing statements are both optional. But the challenge candidate and the challenger, if they would like to, will be given 3 minutes. So this is an example of when we need the timer. And they'll make opening statements. And both opening statements and closing statements, they're not evidence. You can't use it as evidence. What they're meant is to kind of set the stage. So make sure that we all have the same understanding of what we're doing. That's the purpose of them. So again, not evidence. Preview of the case. And they can be made by either the challenger or the candidate or their attorneys. and we may or may not have attorneys. All right, next slide is the case in chief. So like I said, this is the meat of the game. This is why we are here. So there are several pieces to the burden of the proof. So we have evidence, so that's documents and objects that can be entered into the record. So that's something that either party can provide. And then there are witnesses and testimony. So a witness can come up and be called to give testimony. The candidate and the challenger also have the option to do that too. So that is technically still a witness, but we're kind of going to break it out so that we make sure that that everyone knows that they can provide evidence, they can call witnesses outside themselves, or they can give testimony themselves. So for the evidence side, again, that's documents, affidavits, that sort of thing. Those will be presented, and we're asking that they present each piece of evidence one at a time. And then the chair can admit that evidence or not. So the chair will decide whether or not to admit that into the record. The opposing party can object, and the chair rules on that. Or the board can object, and then there'll be a motion of whether to accept it or not. So that's evidence. That's how we get evidence into the record.
So just as a clarification, so if the board, so normally what will happen is the chair would make, like somebody would try to submit an evidence, and let's say someone objects to the evidence, the chair will either uphold or either sustain or deny the objection. There is a possibility that all five of you may not agree with that decision. If so, then you need to let the chair know that, and then you would take a vote as to whether or not to accept that evidence. So it's kind of, the board has the ability to override the chair's decision based on a majority vote. But normally the chair would be making that decision, and if you don't object or you don't disagree with the chair, you don't need to insert yourself in that.
Yeah, you could imagine if they took a vote every single piece of evidence, it would take a very, very long time.
We would just say I object
If we had a different view.
Yeah, I think you just let the chair know that you disagree with her decision and would like to have the board vote on that.
Maybe
Okay.
maybe like respectfully object.
Yeah.
Okay.
Where can these initial objections come from? Can a member of the board object to one of the parties in this submitting evidence?
I don't think the board should be making any objections on the evidence. I think you have the ability to weigh, let's say, the credibility of the witnesses. You have the ability to weigh the credibility of the documents in your decision-making process. So you don't necessarily need to object or not. I think the objection would either come from the candidate or the challenger. I do not think the general public can object to a document being admitted. So I think it's either the candidate or the challenger that could file an objection. And most objection would be that the document is what's called hearsay.
Right. Okay.
Basically, the document is, basically testifying on someone else's behalf, and unfortunately, you can't cross-examine a document.
Right.
That I think would be the main one. Either Amy or I will be able to explain to that, but there are exceptions to hearsay. So, such as a business record, right? Like a voter registration card is hearsay, but it's also a business record kept in the normal, ordinary course and scope of business. Hence would be allowed to be admissible as admissible hearsay. If that, I don't want you all to go down the hearsay rabbit hole, but
Thank you for getting at least into the fringe of the weeds on this thing, because devil's in the details, and I really appreciate hearing from you that if an objection is going to be raised, it should be raised by the challenger or the challenged, and not someone,
no.
not anybody else who's in the room. So
No.
thank you. That's very helpful.
No, and I think the other thing is that you would also allow the document to be on the record, but just note that there was an objection to it. So that, you know, if the State Board of Election, let's say, if they take this up, they may decide differently, but at least, you know, everything kind of goes on the record. But if an objection stained, you shouldn't consider that document. Does that make sense? But it's still there with like an asterisk, I guess, or something like that.
A complete file is always a good idea.
Yeah, what
Thank
we
you.
would do is things that are admitted, we would make sure that you have, so that when you're deliberating, you have it. If it's not admitted, we keep it, we mark it that it's not admitted, but you don't have it for your evidence.
And the other thing that's kind of weird with the statute that I want to point out is that the parties can submit affidavits. So technically, an affidavit is a sworn statement by an individual. Unfortunately, in most judicial hearings, you can't cross-examine an affidavit. So, you know, so I would think that if somebody submits an affidavit, there could be a hearsay objection, but the board would still need to accept it because the statute expressly states that the parties can submit affidavits as evidence. So just to keep that in mind, that little nuance.
Yeah, and
Thank you.
If we need to get.
that's what I was
Yeah,
gonna say.
no.
I think that these really kind of fine
Yeah.
legal pieces is why
That's-
we need to make sure Kurt.
That's what our role. So the county attorney's office, we will be sitting in the role of advising the board. So we will help you with any of these evidentiary questions or anything like that. We will provide you with guidance. That does not necessarily mean you have to accept what we say or whatnot. It's ultimately up to you as to what to decide. You are the fact finder. You weigh the credibility in this, but we will happily give you advice.
All right, thank you, Kurt. So that's the kind of evidence piece. So then the other piece that they can do is the witness piece. So like was asked at the beginning, all of the witnesses will be placed under oath. Glenda will do that. And that includes the candidate and the challenger if they want to do testimony, but they don't have to. And witnesses are not required either. The party that calls the witness will have direct examination, and then the other party can do cross-examination. And then after that has happened, the board can ask questions. So that's kind of how the witness process works. Witness comes up, the person who calls the witness gets to ask him questions. The other party can cross-examine. They can only ask questions related to the original question. Can't start asking new questions.
And if that, begins to happen, that's
Glenda,
when the chair says.
and I think that's another place where Kurt or Amy could support.
Would the board be similarly constrained in its questions?
I believe so. That's a great question.
I think that your questions need to be relevant to the challenge that
Okay.
witness,
That's
but I
easy.
don't, but you know, obviously don't ask them about, things that aren't relevant. But I think as long as the questions, and I would say this too on cross-examination, I think you want to err on the side of letting people ask questions as opposed to shutting that down. But allowing, the questions need to be relevant to the hearing and relevant to the challenge.
Thank you.
Thank you, Kurt.
Oh, and one other thing while I have my microphone on that I want to say, if there are attorneys here and the attorneys start talking, the attorneys are not giving testimony. Do not treat what the attorneys say as testimony. The attorneys make arguments, but they are not testifying. And sometimes attorneys are their questions may also sound like testimony. So I just want you to be sure that attorneys are acting as advocates, but they are not giving testimony.
Well, if you have an attorney who seems to be interested in giving testimony, why not offer to swear that attorney in?
Well, I usually when in my other hearings, and Glenda can think, like yesterday, I had a Board of Adjustment hearing where I had an attorney who was essentially, reiterating what his version of the facts. And I said, counsel, do you have a question for the witness? that's testimony. But I just want you to understand, since this is your first time, and I don't know how aggressive, whether everybody's going to come with attorneys, some may, some not, but I just want you to know what the difference is between witness testimony and attorney making an argument.
Thanks.
Yeah, good point.
Yeah, I got to watch that meeting for several hours yesterday.
I'm sorry.
Right after that.
Well, I was chewing.
Oh, my.
One point is that the challenger, so not the candidate, but the challenger can't be questioned unless they're subpoenaed or they give testimony. Because remember, burden's on the candidate.
So the challenger so the person who submitted the challenge may be able to submit documents to you, but if they want to testify, they have to do it voluntarily, or they have to have been subpoenaed as a witness. And I believe the deadline for subpoenaing witnesses, because the board is the one, or we are the ones that would be issuing the subpoenas, is the 17th. So,
Okay.
so that's going to be, so just to keep that in mind.
Saturday. Yep, and they've all been, been noticed.
So they've been
and given
told
these
that if you
deadlines.
want us to, now, people can come up and testify voluntarily, right? A subpoena actually is compelling you to come, like, so hopefully we will not have to issue any subpoenas, but
I was gonna say, there haven't been any requested to this.
Correct.
did you have a question?
The deadline today for subpoenas on witness.
Oh, I'm sorry.
17th. Yeah.
Oh,
There's
is it
two.
today?
Subpoenas are 5 days.
Oh, okay. So I guess we will know.
That makes that makes sense because we need time.
Yeah,
to
I
be
was
able to
gonna
get-
say, trying to serve a subpoena on Martin Luther King holiday is
Yeah, it wouldn't
probably
work.
not gonna be very easy. So
So deadline
good.
today at 5.
So we'll know in 2 hours and 28 minutes.
Yes.
Okay.
Okay, great.
Cautiously optimistic on that one.
Yes. This is what we're going to be basing our decision on, this part of the hearing, right? And so it's important that everyone's listening, that we have order, and that you ask the questions that you need to make your decision. Again, it's very important that we're remaining civil no matter what everyone else is doing. Glenda will maintain order, but I just really want to reiterate it because once we close, that's it. There's no more admitting evidence, and that's what you're going to have to make your decision on. So it's the most important part of what we're doing. Are there any other questions in that piece? And we can come back to things at the end of the presentation too. So then the next phase would be the relevant audience testimony. So when Glenda is giving her introduction, one of the things she's going to say is, audience, if you already know that you want to give testimony, raise your hand. Gabrielle will bring a piece of paper to them. They'll write their name and what their topic is. So that will help Glenda, when this time comes, she'll have that list, she'll be able to call them and then decide whether we're going to let them give testimony or not. Or provide evidence. They can provide evidence too.
So I just want to maybe give some comment on this because a lot of times at public meetings, people we have public comment, right? The commissioners always have public comment and other type of board meetings have public comment. This is not the place for someone to, well, a quasi judicial hearing is not the place for someone to give public comment like I feel, or, to kind of just like state their thing. They actually have to have some type of testimony or evidence that is relevant to the issue at hand. And I think that needs to be very clear, or, that's, I think, when things are going to kind of, because it's very hard to like draw that line between what's a public comment and what somebody's testifying. So you as the board member are going to have to weigh the credibility of the witnesses and things like that. Cause I don't think we want to be openly shutting people down because not everybody is going to follow the rules. So just keep that in the back of your mind.
Okay, but taking public comment during a quasi judicial hearing is inappropriate. So in any case, if I would think if someone wants to participate, they're gonna have to be sworn in.
Well, they would, and they would be subject to being cross-examined by both the parties too. But I'm just saying that even though, and I've seen this happen in other situations where people will come up, get sworn in and not actually present evidence. They'll just, say, I don't think this candidate should be,
Okay.
that kind of thing.
Okay.
That then is where you as the board are kind of put in a position of, do I shut? Because you need to be consistent on how you treat all the people standing up. So if you're going to shut one down, you got to shut everybody down. But if you are going to allow one, you may just let everybody have their, I'm kind of the opinion is that you may just want everybody to have their say, and then you rule out, or you determine what is relevant and what is credible and what is not.
I'll have to see how many people are in the room before I make that determination.
Okay. Well, I'm just trying to give you, I totally understand. I'm just trying to give you that gets to be very thorny. And that's where I see a lot
Okay.
of
Would it
it.
be,
I like that the procedure that Director Duncan outlined, though, where someone who wants to say something has to identify themselves in writing and put the subject of their commentary in writing. And so
I agree. And I think that's
Director Duncan's going to have an opportunity to vet this stuff with our chair before determinations are made, I would think.
not me. I'm-
I don't think
I'm
Director
absolutely-
Sorry, Glenda, it's all in your lap.
Well, she'll have a list, and I think what you'll do, you'll look at the list. If that list and what that person puts down appears to be relevant, and that's a pretty broad standard,
Understood.
let them come on up.
Right.
And the other thing you may want to do, well, I usually don't like to do this, is put a time limit on what people have to say. So, that's another option. I'm not sure, but
Good
once
option.
again, you go in with good intentions. There's going to be somebody that's going to abuse that. So
Is it appropriate for Glenda to, if things start feeling fuzzy, is it appropriate for Glenda to say, can you state how you think this will impact the decision or something like
It-
that? Like,
it is, and I think you can do that. But I think what I'm trying to do is avoid having Glenda to make, because everybody, depending on how many
Fair.
you have, you need to be careful about, are you going to shut one down, but you didn't shut so and so down, and
Sure.
you're going to have a crowd, and some people aren't necessarily going to agree with that. So I'm kind of trying to just give you like kind of a heads up that it's kind of like either you're really strict or you're not. There's not really an in between. It's hard to get that
It's the
exactly.
consistency that's crucial.
I totally believe that is the main thing.
Right.
Yeah, Marianne.
Yeah, I was just curious, since we are only giving the parties 3 minutes each, wouldn't that be reasonable for anyone else?
well, the 3
Well,
minutes.
those are for opening. Those are for just opening statements, which is not testimony and which is not, that's just more or less their preview of the case. So that's not evidence. That's just them saying
No
what they
limit
think
on
it's
their
going to.
evidentiary.
Right. So if a witness is getting up and testifying, we don't put a time limit on that. But what you're trying to do is weed out what is actual relevant testimony to the case and what's just public comment. Political
Yeah.
grandstanding, shall we say.
There's some human things going on here, right?
Yeah.
If we have a crowd in media, somebody might want to just go up and talk about their own candidacy, right? We want to avoid that. It needs to be relevant to this. And I think another human thing that I just want to say out loud too is I think that could be a time of people saying things that might trigger the board, right? So make sure that if we're just here listening, right? Yep, don't react to what they're saying. Your time to react and to ask questions is during the deliberation.
And I also believe that anybody coming up and is wishing to speak, if they do give evidence, the board would also have an opportunity to ask them questions should you wish.
Yeah, yes. Yep, so we basically have the candidate and the challenger. They both get their time to provide evidence and speak and have witnesses. That gets done. Then we have public who also gets to do the same thing. Then evidence is closed. All right,
Will we have something set up for public comment?
we'll
Where
have a
they'll come
podium.
to-
Yep, great question. Okay, so closing statements, very similar to the opening statement. So the challenger and the candidate can kind of draw things up. They only have 2 minutes for that. Again, not considered evidence. The point is just to try to make sure that everyone's on the same page. And again, the person, the challenger or the candidate or the attorney can do this. And then the decision and deliberation. So this is after the closing statements are finished. Again, no more evidence can be admitted. So now you're making your decision on the things in front of you and what you've heard that you admitted to the record. So you'll deliberate and you'll do that in an open session for as long as you need. At any point during that, someone on the board can present a motion. Question.
The decision's going to need to be documented. The law requires it. And
Mhm.
when we are doing our deliberation, one of the things that I learned from doing this before is how important it is to make findings of fact. And you just list all the things, all the facts of the case that we all agree on, and then everything else kind of falls into place. But it's those findings of fact that I learned were really the bricks of, the foundation for
I think
our
that it would
decision
be
here.
useful to give the board a template of what a written statement looks like. So
I
that
could
can
give
see
you a
the pieces of
proposed,
it.
I mean, we can try to send you all a proposed order, or at least, I hate always referring to the Board of Adjustments, but I could give you a proposed order that we do. Well, that's really the biggest quasi judicial
Right.
body that we have that we do on a regular basis. I can send you a sample order but you are correct. The findings of fact, you all need to, or at least a majority of you need to agree on the findings of fact. Like usually what we will do is agree on the findings of fact. And once everybody agrees on the finding of fact, then we can make a motion to either approve or deny
The challenge.
challenge. Or so that way you have your, what you consider or that was relevant or whatnot.
Okay.
And so that will, but we will be there to help you do that.
But the motion will be whether to
Well,
upheld or-
we could theoretically break up the motion where one motion is I move that we adopt the following findings of fact. And then you would list out or if, you all kind of have a consensus, you list out what you agree are the findings of fact, that we find that exhibit as, and then after you all vote to approve the findings of fact, then somebody makes a motion. I make a motion to either approve based on the findings of fact. I move to either approve or deny the challenge.
Thank you.
Can you make note of that, Nate?
But yeah, that template
Mhm.
is such a handy guide.
Yeah, it'll help you kind of know where we're aiming
Yeah,
for the
yeah.
written statement. Because we've got to do two. We have to do that decision in the open meeting and then issue a written statement, which has pieces. Okay, that's deliberation. Again, technically, we have 20 days to issue that written decision, but we want to do that quickly. So we'll try to be prompt. And so we'll aim for the next day. Of course, if we need more time for some reason, then we will take more time, but we'll try to be prompt.
Isn't this decision going to determine whether or not we have to reprint ballots?
Yep.
Oh, okay, good question. So there are two different candidate challenges.
Right.
One is county and one is municipal. So there are different rules for those. Yes. So the county challenge, and there's another challenge in another county. So the state board is looking into this. One big nuance, I don't know, those kind of butt up against each other. A caveat is that Remember we used to have elections in May,
Yes, oh, bring them back.
right? We used to have elections in May and then we moved them to March. Well, when we did that, we have rules that are overlapping. We have to send out absentee ballots on the 12th of January. And we also have to have candidate challenges. And they just have not caught up with each other. So it is unclear for the sheriff's office what would happen in that case. So that would be more state board consulting. So if you decide that
So in other words, if we uphold challenge, then it goes to the state board to decide.
No, if you uphold the challenge, you uphold the challenge. Then we need to talk to the state board and figure out administratively what we do. Yes, yeah, the state board doesn't decide. And I want to say something else on appeals after this. The other case is a nonpartisan municipal primary. And there is a statute under death of a candidate that says, in the case of death of a candidate, or the candidate otherwise becomes ineligible, which would be this. Then you check to see if there's time to reprint the ballot. Pretty obvious, there's no
It's not
time to
done.
reprint the ballot. We have sent them out to voters already. So in that case, the candidate's name would remain on the ballot. We would have the election. If they are a top candidate, they just don't get counted and the next one moves up. That statute is clear.
You still count the votes.
The votes still get counted. Yep.
They're not a candidate.
Yep. And I can send out that statute.
Well, the name
Good.
is on the ballot, so.
Well, yeah,
yeah,
but I mean, you can
yeah.
program the machine so it doesn't count that individual.
Yes. I
But
think that we had this case before in a
Hmm.
death.
it does sound familiar.
Yes, I think we did. Where they passed, like during early voting.
Right.
So those are the two cases there. So we'll cross that bridge when we get there. But in the municipal case, I have checked that with the State Board of Elections and they agree.
Good.
The appeals. So the other complication with this and the May primary moving to March is that the decision can be appealed. So if the decision is appealed, it first goes to the state board. They have to appeal within 2 days of our written decision. So when we serve that written decision, they have 2 days to appeal. They appeal, they can appeal to the state board. If they don't like that decision, they can appeal to the Court of Appeals.
Essentially,
They could stretch it out.
Well-
Yes, that's why we need to be swift.
it can, but it appears that the appeal to the state board is based on the record that you all create so it's not, it won't be what's called a de novo or a brand new hearing. They would be basing their decision and looking to see whether you all, were being arbitrary and capricious and ignoring the facts on the evidence, or whether you all committed an error of law. I think that's all that the board, that's both what the appellate court, the state board would be looking at you are the fact finder. They would be looking at whether you all acted appropriately. And then if the state board's decision got appealed to the Court of Appeals, it would be the same type of review.
That's my understanding too.
So that is why it is important that we create a very good record. And that's why we're taking a transcript of all the testimony and documenting all the evidence, whether it's accepted or not.
Yep, and kind of being slow and deliberate and repeating things. That's intentional. All right, this is our last slide, and Kurt I definitely want you to step in on this one. So this is that legal standard. So there's different types of legal standards for different types of hearings. And this standard here is preponderance of evidence. So this is not beyond a reasonable doubt. This is preponderance of evidence. This is that there's more evidence towards one side than the other side. So again, once challenged, the burden is on the candidate to show by a preponderance of evidence. So the candidate needs to show you that they are qualified. So that's the question that the board is examining.
Or that's what your decision would be. Is it more likely than not, 51%? Those would be the two things. And I also think that you need to make sure that it's based on competent and material, it's based on evidence. The decision is based on facts that were presented. But, I think it will be very clear as to whether, I don't think there's like going to be like a middle ground or anything like that. I think it's going to be very apparent one way or the other, depending on how the evidence goes.
And we tried to kind of make a plain language statement. So preponderance of the evidence means proving something's more likely true than not, like tipping a scale in your favor, over 50% probable. It's the standard of proof in most civil cases, requiring that the evidence is more convincing, not absolute certainty, but more convincing to show that a fact is true.
And some of the things that would affect that is the credibility of the witness, right? And that is your role as the panel and the judges. You will be weighing the credibility of the witnesses as to whether is that person believable. Do you think that what that person's saying is true, correct? Does it, so you will be judging, because you may get conflicting testimony, and it is your job to determine, who you're going to believe more or less, or who you think is right, and what documents, you may get documents, what documents are credible. I mean, obviously business, hopefully you will be given a bunch of business records that, the government creates, so that's not, so you don't have to question your authenticity. But if you get an affidavit from somebody, you have to weigh how much weight you're going to place on that document in your decision. Does that make sense?
And that is my presentation. So are there any more questions?
One question about public comment that somebody asked about. What's that going to entail?
There should not be any public comment. They would either be presenting evidence or they shouldn't be
Maybe I
speaking.
misunderstood, because that's
Yeah,
what I
no,
thought.
I think that we just said that we're going to have a podium for people who are not the challenger and the challengee
Just the witnesses.
come up to be,
Yeah,
to
okay.
be, come up and speak.
All right. Another couple of questions. There haven't been any requests up to this point for depositions, I assume, right?
Correct.
Okay. And when I was reading through the law, it looked like that the challengers have 10 days post the day of closing for filing for candidacy. And these two happened post 10 days. So I'm trying to figure out what that means.
So they have 10 days. They have 2
10
days after the close of filing
Let me,
to file a candidate challenge.
Talking about whether you have jurisdiction to even hear it. You're
Yes.
talking about jurisdiction. So they have to file their appeal within a certain period of time.
on appeal, I mean.
Their challenge,
yeah,
right?
uh-huh.
I'm sorry.
Uh-huh.
If their challenge was filed outside of that, you have grounds to dismiss.
So both of these were filed outside of that 10 days.
One of them was filed on the last day.
So when was the
But it's
last
the
day
ti-
of
10
deadline-
business, remember, it's 10
It's 10
business,
business
it's 10
days
business
after the
days.
close of filing.
But wasn't that December 19th when we closed
Well, business days.
candidacy?
But also remember, there
understand. I'm
were a
just
ton
trying
of
to add it up.
holidays and the county was closed for some of those days too, and you can't count those and you can't
Well,
count the weekends.
Is it important that we know
Yes.
what those 10 business days are?
Yes, we verified it with the State Board of Elections.
Okay.
Yep, and we verified the 5 p.m.
Thank
Because
you.
I thought, we ended at noon. Does it stop at noon? But it was at 5 p.m.
Okay, thanks.
Excellent question, Sally. Thank you.
Mhm.
There was a way that we could have gotten you out of this. We would have brought it to your attention, trust me.
Great question.
That's all I have, I think. The one other question, which I think you pretty much undertook for me to understand, was that, I first said, how does the chair decide on the evidence? So I think that's pretty clear about, again, how it pertains to the case. What other areas of decision would she have to make a yes or no on deciding what the evidence is?
Well, it's not so much deciding what the evidence is, but it is deciding whether to admit something on the record.
Okay, so
Okay,
how
so
does-
she's not deciding whether that evidence is good or bad, or whether
Okay.
you consider it or not. She's basically, it's, the chair would basically be deciding, is that hearsay? If it's hearsay,
So-
is that something that should be, in a regular proceeding, should that evidence be allowed into the hearing? So it's not, but you as the judge, or you are more or less weighing how much weight you give that evidence, the importance of that document. You are more determining, how does that document play in
Back to the
to,
finding
to
of
the thing?
facts.
Yeah, it's more, yeah.
Okay.
Does that help?
I think so.
So she would be
it-
making decisions about, is someone acting out of order, trying to maintain order. But most of the questions in a quasi judicial are admissibility of the evidence. And while we're supposed to follow the rules of evidence, we're not required to follow it for the T. You're not lawyers, you're not judges, so you're not expected to know, chapter 8C of the North Carolina General Statutes about rules. But I guarantee you that with Miss Broughton or I, we'll be able to help steer you as to with that. But
Everybody good?
Good.
I can hardly wait.
So, Kurt, anything else you'd like to share?
no, I just think that we just need to be ready that if there's somebody that requests a subpoena tonight, that we be prepared to issue those. So I would think that we may want to, probably first thing tomorrow morning, is if we need you to sign something, because you would be the chair. But otherwise than that, I don't think there should be any other thing. So
Okay.
I'm going to knock on wood and hope we don't have to do
And they've
that.
got to what, 5 o'clock
5
today?
o'clock
Mhm.
today.
Close of business.
Okay, one other thing that may happen is that witnesses may refer to things that aren't actually into evidence, right? So they may refer to somebody's voter registration or somebody's tax records or something like that. Ideally, we want the parties to be gathering that evidence and presenting that evidence to you. If, though, it is something that is a public record that Buncombe County maintains, you may take judicial notice of that. And what that basically means is you say that is a valid document. That is something that the county maintains in its regular court. So they don't necessarily have to present that document, and you could then be allowed to consider that. Hopefully, you're
Fine.
not doing that a whole lot, because that means neither side has prepared their case. But that would be the only thing. But I would be cautious, because one of the cases may involve tax records from the
Right. I mean,
from the county of Georgia.
Yeah.
And unless those, I don't think that we could take judicial notice of those, because I can't vouch for because I can vouch for the Buncombe County systems and stuff like that, but I cannot vouch for what goes on in Fulton County, Georgia. So just if that helps, they would need to have
The evidence. Yeah.
they should have a certified copy from the tax assessor of Georgia if they're presenting that kind of evidence.
Yeah, so that would depend. That would be whether they've prepared their case, and if they haven't, then we can't consider. it.
Right. Ideally, you all want to be coming in this as neutral. So I would say that and I think it's very important that you only, when you're deliberating or when you're deciding the case, that you only look at the evidence that was presented at the hearing, not the news articles that you read outside. You don't want people, hopefully people have not been trying to contact you and asking questions. Those are called ex parte communications. If somebody does do that between now and the hearing, document it, tell them you cannot talk to them about that, but we need to maintain a record of that so no one can accuse you all of somehow deciding things out of the thing. So I'm just curious, has anybody been contacted?
I was contacted by Ms. Mosley right after that AVL Watchdog article came out. No challenge had been filed. No challenge was filed for quite some time. In fact, I didn't think one was going to be filed the way the calendar was flipping. But anyway, I described how the process works. She was concerned about being able to give her side. I said, we use due process. So both the challenger and the challenged have the opportunity to present their cases and tell their stories.
Nate and Corinne, I think what we may want to do is at the beginning of the hearing, we poll the board to see whether anybody had any ex parte communications regarding the hearing. So in Annette Mosley's case, we would ask, has anybody had ex parte? You can then state that and put that on the record so that no one can accuse, so that it does not appear that anybody's doing anything behind closed doors.
Good. Thank
So
you.
that's kind of what.
No, I would like to do that because my name was cited in a news article.
No,
that
I
had
don't,
a
I don't
problem
want
with.
that. So just in case anybody else gets contacted, the proper response would be is I cannot talk to you about this matter and document it. I think you are a different situation because that was before the challenge happened. But nonetheless, I think you voluntarily disclosing that should clear up. And then you just need to say that nothing in that conversation is going to affect my vision to implement a fair and impartial, to make a fair and impartial decision based on the evidence solely presented at this hearing.
Transparency is the way to go.
But
Absolutely.
it could, I guess I'm thinking about the hard versus soft evidence because it was documented in a newspaper article later, right? What was said about that? Wasn't there something about that you had given her information?
Yeah, Ms. Mosley, in one of the news articles said that she had spoken to me.
Right. So it's also out in public that she had spoken to Jake and she'd been given the impression, bloody.
She developed the impression.
Developed.
I just told her
she
how our
developed the
process
impression.
works. And she felt, after I described how the process worked, she seemed to feel
But
confident.
it is out in the news. It was out
Yes, it
in
is.
the
Yes, it
newspaper.
is. Hey,
No, I get
I'm
that.
all
and
about transparency.
I think that would be that. I think, I mean, Jake, you do have the option, I think, potentially of saying that, hey, you have a conflict. And if you don't want to consider Annette's case,
I don't have a conflict.
well, I'm just saying that, that's ultimately what happens in situations where, let's say, it does kind of cross that line. I would advise the board member to recuse themselves from making a decision on that specific case. I don't think that at this time, I don't think I could say that Jake has a conflict, but I think we want on the record that him saying, I'm going to base my decision based on the evidence presented at this hearing.
Right. And that's exactly what all of us are going to do.
Oh, I know that. I'm
Right.
not,
So
I'm
that's,
just wanting to.
To
I
say it
think-
out loud. Yeah.
I think that it is a good example of when we're talking about weighing the evidence, right? Here's a newspaper article that says some
Exactly.
things, right? So we need to keep those types of things
But-
in mind.
But once again, the newspaper article's not evidence. That is more, that is hearsay upon hearsay upon hearsay. So that, but, so just in case somebody does, I could see somebody trying to
Sure.
present the newspaper article, but
will.
that's not necessarily the facts.
and
You
I
need to-
think all those writers are going to be here. So, I mean, all the reporters are going to be here. Everyone who's covered this story is going to be at this meeting.
Right,
So,
but I think you're more interested in what are the facts to prove
Exactly.
the residency issue, how do you prove, what
I think the important thing for everyone in the room on the 20th to understand is that we are all going to hear the same evidence. And that is all of the evidence that will be considered by the board in making a decision. And everyone's going to hear it.
that's a fair statement.
I just want to be clear. If someone presented a newspaper article, they wanted to put this into evidence, Glenda's response would be no.
Well, if someone admits it, and let's suppose that neither party objects to it, I would allow it into the evidence because I don't think that you want to be deciding what evidence you're going to put on. And then I think based on our conversations, then you could say, oh, well, this is hearsay. This isn't really fact. This is,
I understand.
so then you just not pay much attention to the newspaper article as opposed to just banning the newspaper article. And then, it just,
Yeah.
you don't want to do a bunch of self-inflicted wounds. You know what I'm saying? I think what you want to try to be as fair as possible, as open as possible, allow as much as you can. And, you all can weed out what's relevant and what's not.
I think that's a very good point, though, that the weeding out happens during the deliberation when you're saying, this is fact, this is not fact.
It would be interesting to me if someone tried to present the newspaper article and the challenged would not object.
True.
Well, I've seen it happen, but I really think that you all need to understand it is not your decision to make either party's case. That is not the role. You are the role to judge their case. I mean, the candidate has the burden of proof, so that means the candidate has to show, basically more likely than not that they're that they are eligible to run for the office. Yeah.
Good thing I don't read the newspapers.
All right. Hearing no further questions or comments, our next meeting is obviously the 20th at 2:30 in this room. I would ask that the board arrive by 2, please, so that we're all present and ready for the proceedings to begin promptly at 2:30.
I'll be ready. Ready.
Hearing no further business, may I have a motion to adjourn this
So
meeting?
moved.
This meeting is adjourned.
Thank you.
Require a second.
Nope.
Nope.